I'd like to remind everybody also that if you're down here in your ID, if it says iPhone or a phone number, if you can change your name to that so we can see who you are, pretty please.
All right. This hearing is these hearings, plural, are being conducted remotely on Zoom and live streamed on the court's YouTube channel. No recording of these hearings are permitted other than by the official court reporter. Any violation of these instructions are punishable by contempt of court. Please mute your microphone and only unmute when you're speaking. Please do not speak over other participants. If any of the attorneys have an objection, please state objection and wait for the speaker to stop. If the speaker doesn't stop, I'll intervene. And then briefly state the basis of your objection. During this hearing, do not use the chat option on the options bar unless the court grants permission. If anyone needs to have a private attorney-client conference or a sidebar conversation, you may be asked to be placed in a breakout room for a private conversation. I am automatically invoking the rule for exclusion of witnesses in all Zoom hearings other than parties and attorneys. Any witnesses will remain in the Zoom waiting room until they are called to testify. While waiting to testify, witnesses may not view or listen to the YouTube live stream, and parties may not communicate with witnesses. Witnesses will be called in as they're called by the attorneys. Does anyone have any questions about the rules for Zoom hearings? All right, I'm going to call the docket, beginning with the protective order docket. I'll ask you to please make an announcement. Marreri Martinez versus Carlos Acosta.
I'm here on that case.
All
I'm
right.
the Attorney
You
General.
represent the petitioner.
I'm with the Office of the Attorney General, Your Honor.
All right. More people are showing up late here. And is anyone representing Carlos Acosta?
Yes, Your Honor, and that's me. I apologize. I was here and then I saw where I was supposed to be in another Zoom, but I've come back here. Jacqueline Blott on behalf of Carlos Acosta.
All right. And have you all conferred?
No, Your Honor.
Do you need to confer?
I don't believe so.
All right. And then Yesenia Alvarado versus Mauro Lujano Juan. Ms. Flores, Bianca Flores, or anyone representing anybody in that?
Your Honor, I'm also here representing the AG's office on that as well, but it's not our motion.
And then Christy Rutherford and Orlando Rutherford. Anyone here on that case?
Yes, Your Honor, we're all here, except for, I don't believe Orlando Rutherford. We had service by publication on this. We have an attorney ad litem, Marshall Sales, who is here. And it looks like my client, I was in touch with her here. I see her picture. So I think she's here. She's muted.
All right. And that's a merits case?
Yes, Your Honor, it's a divorce.
All right. And then Sierra Crothers versus Lawrence Parrish.
Good morning, Your Honor. Elizabeth Tristan with the Travis County Attorney's Office on behalf of the applicant, Sierra Crothers. She is present on Zoom. I also see the respondent, Lawrence Parrish, on Zoom. And if I could just have an opportunity to confer with the respondent in a breakout room, I would appreciate it.
All right.
Yes, ma'am, I'm here.
All right, I see you, Mr. Parrish. And who was it that was speaking? Was it Miss Loveday?
No, Elizabeth Tristan.
Oh, okay. And you want to be placed in a breakout room?
Yes, Your Honor, with the respondent, Mr. Parrish.
All right, and what about your client, Ms. Crothers?
She is present, but I would like to speak with Mr. Parrish.
All right.
Separately.
I'm on here.
Got you, Mr. Parrish.
Yes, sir.
All right, Ms. Tristan. And Mr. Parrish, there you are. All right, I'm going to assign you to a room, Ms. Tristan. When you're ready to come out of there, if you would just let Elizabeth Lozano know, you can do it by either, I assume you may have her phone number, and if you don't, you can use the chat function on Zoom.
Yes, Your Honor. Thank you.
Mr. Parrish, Ms. Tristan, you should receive an invitation to go to the to the breakout room. All right, Haley Pluitt and Kenneth Pluitt.
Hillary Riley, Assistant County Attorney, appearing for the state of Texas. Ms. Pluitt is present. I'm not sure if the one labeled iPhone is Mr. Pluitt or not. I know he was holding an ID up, but I couldn't read who that was.
I don't, I've asked him to unmute.
Haley Pluitt is here.
That's fine, we've got you. Well, I'm asking that iPhone to unmute, but they're not unmuting, so I have no idea who that is. Somebody's watching us here or attending on an iPhone that doesn't have a name on it. Would you unmute yourself and identify yourself, please? All right. Well, I'm going to assume they're just a spectator. And then, so this will be a default then, Ms. Riley?
If Mr. Pluitt does not appear, then yes, it will be a default. We had reset from a previous setting at his request. And if he doesn't appear, we'll be ready to go forward.
That's what I understand. All right, Haley Loveday versus Shane Leininger.
Your Honor, Lauren Cisneros, Assistant County Attorney for Travis County, here on behalf of Ms. Loveday. I do not see Mr. Leininger unless he is also maybe the person that is the iPhone.
Well, the person that is the iPhone won't identify themselves and they won't unmute their phone. So as far as I'm concerned, they're not here.
Thank you, Your Honor. The service return has not been on file for 10 days in that case. So we'd be asking to reset for default to get the notice on file.
All right. Would you deal directly with Elizabeth on that, please?
Yes, Your Honor.
I'll certainly approve a reset. All right. Those are all the cases I have on the two dockets I've been given. Is there anybody else who was told to be here whose name or case was not called?
Your Honor, I joined a little bit late. My case is Espino Yesenia. It's a motion to enter an order.
And Your Honor, the AG is also on that. I'm not sure if I was on mute when I said that earlier.
Yeah, I called your case and the AG announced, Ms. Flores, but we'll be with you in just a minute.
Thank you, Your Honor.
All right.
And Your Honor, I also logged in late for Merari Martinez versus Carlos Acosta.
Yeah, we called that as well. What's your announcement on that?
I haven't conferred with opposing counsel, but I would estimate 3 hours.
To enforce temporary orders?
It's a modification as well as competing enforcements.
Do y'all want to confer? You'll be the last, if you're 3 hours, you'll be the last case I'll hear today. So I can put you in a breakout room and you can confer if you'd like.
Sure.
That's fine, Your Honor.
That's you, Ms. Plott?
Yes, Your Honor.
All right, let's do that then.
And Your Honor, I'm also here on that one. I'm not sure if I was on mute earlier when I said that.
Who is that talking? Ms. Latham?
Allie Latham, yes, with the Attorney General's office.
You want to be in the breakout room?
I'll speak to them briefly, Your Honor.
Okay. All
And
right.
I just be notified or brought back out to participate in the Miss Bianca Flores' matter when it's ready.
Let's see, who is the other attorney involved in that? Ms. Sanchez?
Yes.
It's tough when you have old judges trying to do new tricks with Zoom. All right, I think everybody should have gotten an invitation to go into the breakout room and go on. All right, I'll call first the Carruthers versus Parrish protective order. Parties ready?
I believe they're in the breakout room. Ms. Tristan is talking to Mr. Parrish in the breakout room, Your Honor.
All right. And then the Fluid case will be as long as we reset. Elizabeth, is that correct?
No, Judge. The one that's going to reset is
Oh.
going to be Love Day.
Love Day. All right. All right. Haley Pluitt versus Kenneth Pluitt. Are we ready on that?
Hello. Hello.
Yeah.
Hello.
Mr. Pluitt is the one that's marked 281, I guess. I'm not sure.
Pluitt, I've been asking you to unmute yourself and to identify yourself.
I apologize, Your Honor. I've been trying to figure out how to work this. I apologize for interrupting. I'm Zane Loniger, part of the Haley Loveday case.
Who are you?
Zane Loniger. I'm
right.
with part of the Haley Loveday case. I've been trying to figure out how to unmute myself.
Ms. Cisneros, you're involved in this case?
Yes, Your Honor. If I could get into a breakout room with Mr. Leiniger, that would be great.
All right, Mr. Leiniger, I'm going to put you into a separate room with Ms. Cisneros. You'll be able to confer with her without anybody else seeing or hearing.
Thank you so much.
Be patient. You probably will receive a request for you to agree to join, and you just need to agree when your time comes up.
Yes, sir.
Should be there, so join up, mister.
How do I go about that from my phone? Because I don't have access.
First of all, you shouldn't be on an iPhone, but since you are, there should be something.
No, I'm not currently on an iPhone. I'm currently on an Android device, but I don't have access to the internet at the moment. And on the paper that I was given the option to call.
There should be an option for you to join this breakout room.
Where do I find that? Is it a URL?
Should be on your screen.
No, that's what I was saying. I'm entirely in a voice call right now.
Look on. Don't you have a smartphone?
Yeah, yes, but that was what I was attempting to convey, was that currently I do not have access to the internet at the location that I'm at. It's not allowing me to load up any pages on the internet.
Well, I don't know what to do with you.
I'm trying to log into the.
I'd recommend you go someplace where you can join us with a computer and join a breakout room.
Yes, sir. I'm currently trying that right now.
That falls well within the category of not my problem. If you choose not.
No, I totally understand.
All right. I'm going to ask you to be quiet now. All right. Alvarado versus Morrow Lohana Juan, Ms. Flores. You need to unmute, Ms. Flores.
Yes, Your Honor, that's just our motion to enter the temporary orders that were previously signed by both parties except for the Attorney General's office. And so we set the hearing hoping to get their signature so we could enter the order.
Is there an Assistant Attorney General appearing on this case?
Miss Allie Latham. You put her in the breakout room.
Okay. Have you conferred with her? Does she have any objection?
I haven't conferred with her, no.
Okay, well, I guess you get to wait around until she's done in the breakout room.
Okay.
Rutherford versus Rutherford, Miss our own Mr. Sales. Are we ready on that case?
Yes, Your Honor, we're ready.
Yes, Your Honor, we are ready.
All right, tell me what the issues are in the case from the petitioner's point of view.
Your Honor, this is simply a basic divorce. We cannot locate the respondent. We've tried, we had a attorney ad litem appointed, and we did service by publication. So at this point, I don't think that Orlando Rutherford has appeared, and we are simply going through the prove up of a default divorce.
All right, are the children involved?
Yes, Your Honor, there are 2 children involved.
Is there any property?
No, Your Honor, no property of substance, just the possessions that each have accumulated. This is a VLS case.
All right, and Mr. Sales, do you agree with her analysis of the issues?
Yes, Your Honor.
Have you made an attempt to contact your client?
Yes, Your Honor.
And would you tell the court what that attempt is and whether or not you've been successful?
Yes, Your Honor. I did file an, sorry.
Wait a minute.
I'm sorry. Are you going to need this on the record?
Yes.
Okay. Yes. Thank you.
Your Honor, please let me know when you're ready for me to proceed.
You ready, Shannon? All right, go ahead, Mr. Sales.
Yes, Your Honor. I filed a attorney ad litem report with this court on May 15th of 2020. In that report, what I indicate is that I reached out to Miss Barron to obtain the whereabouts of Mr. Rutherford. She indicated that she and her client were unable to reach him. It was their understanding that he was somewhere in Mississippi. I checked Facebook, I checked Google, I checked LinkedIn, I checked all of the different inmate searches for Travis County and contiguous counties. I checked all the different inmate searches in Mississippi and in Union County where respondent supposedly resides. That was completed on May 7th of 2020. I once again checked last week. I believe that was on August 13th. And once again, I was unable to reach with or make contact with Mr. Rutherford.
All right, well, thank you very much. Ms. Rutherford, would you raise your right hand? Do you solemnly swear or affirm that a testimony you may give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
We can't hear you for some reason.
I do.
Okay, that's it. You just got to speak up. You're not muted. You can put your hand down too. All right, go ahead, Ms. Brown.
Thank you, Your Honor. Can you please state your name for the record, please?
Christy Angeli Rutherford.
And are you presently married to Orlando Rondale Rutherford?
Yes, I am.
And have you been a domiciliary of Texas for the preceding 6 months and a resident of this county for the preceding 90-day period?
Yes, I have.
And were you married to Orlando Rutherford on or about December 16th, 2005? And have you ceased to live together as husband and wife?
Yes.
And is there any reasonable expectation of reconciliation?
No.
Were there children born during this marriage?
Yes.
What are their names and ages?
Bryson Jacob Lewis Rutherford, he is 13. Matthew Isaiah Lee Rutherford, he is 12.
Okay, and were any children adopted?
No.
And are you pregnant at this time?
I am not.
Okay. To your knowledge, have you acquired any community property or has he acquired any community property other than personal effects to your knowledge?
No.
And what do you have in terms of property? Just your belongings?
Just my belongings, my clothing.
Okay. And what do you know about what he has in his possession?
I don't know anything.
Okay. And how about debt? Do you have some debt in your name?
Only in mine, yes.
Okay. And are you asking that the court grant you what you have in your possession and him what he has in his possession and what debt you have in your name and him what debt he has in his name?
Yes.
And was there any domestic violence in your marriage?
Yes.
And can you describe that briefly?
Yes, I can. The domestic violence, there was when I was pregnant, pulling off the bed by my legs while I was pregnant to the floor, slamming up against the walls. In October, there was him threatening my life with shears. I was cutting hair at the time. I was a cosmetologist, and him holding shears into my neck and choking me, suffocating me during that time on the bed. So I was unable to breathe. So this was October the 24th, I believe it was a Saturday.
Of what year?
Of 2014,
And when was the last time you saw Mr. Rutherford?
that day. That was the
Okay.
last time.
Are you afraid of your husband if he should return?
Yes,
And are you asking that your address not be included in the decree because he has committed family violence and you are afraid of him?
yes.
And since he left, what has been his contact with the children?
No contact at all.
And are you concerned about the impact of what might happen if their father suddenly appeared in their life after all these years?
Yes,
And are you concerned for their safety due to the history of family violence?
yes,
And are you therefore asking that you be named sole managing conservator with the exclusive rights to make all the decisions regarding the children?
yes,
And are you asking that visitation be at your discretion should he return so that you can handle that appropriately?
yes,
And do you believe that's in their best interest?
I do.
And are the children doing okay now under your care?
Yes, they are.
Okay. And has your husband provided any financial support since he left in 2014 for the children?
None at all.
And you aren't asking for back child support, are you?
No, I'm not.
But are you asking that child support be set at minimum wage as well as a $50 reimbursement for any medical support and a $10 reimbursement for set dental support so that if he should appear again, that he should be held responsible for the financial support of his children?
Yes,
And do you think it's in their best interest to receive financial support?
yes,
And are you aware of the steps that you yourself made and that I made on your behalf in order to locate him?
yes,
And you're aware of a Facebook account which has a posting addressed, presumably addressed to you, that names you from multiple years ago? Do you remember that?
yes, I do.
And do you remember when I showed you that I had messaged that account?
Yes,
Yeah. Okay. And did he, to your knowledge, did he respond to that message?
no,
Okay. Are you asking the court to grant you a divorce and approve all the proposals you have described?
yes,
And Your Honor, if I may share the screen, I just have a few items of evidence that I would like to get in.
The evidence has been forwarded to me by, the proposed evidence has been forwarded to me by the court reporter in an application called Box, and I have it open on my screen here.
Okay, I can just go through it then. So, Ms. Rutherford, are you aware that we published service in the Austin Chronicle?
yes,
I move to admit petitioners one.
I've reviewed it, and Mr. Sales, you have any objection?
No objection, Your Honor.
It's admitted.
And then remember the Facebook message that I mentioned to you before, where he named you by name in a Facebook post. And do you remember looking at that?
I do.
Okay, and I move to admit petitioners exhibit 4.
No objection, Your Honor.
All right, it's admitted.
And do you recall filling out a military status declaration stating that, to your knowledge, he is not in the military, has never been in the military, and told you that he had medical issues that would prevent him from being eligible to enlist in the military?
Yes,
I move to admit petitioners exhibit number 6.
No objection, Your Honor.
Yeah, it's admitted.
And do you remember signing an affidavit stating that his last known address is 10 Colorado Road, 835 Blue Mountain, Mississippi? Do you remember signing a certificate of last known mailing address, Christy?
yes,
I move to admit petitioners exhibit 7.
No objection, Your Honor.
It's admitted.
Other than that, Your Honor, I have no further questions. We ask the court to grant the divorce, and I have a proposed decree upload as petitioner's exhibit number 8.
Yeah, I've reviewed it. Mr. Sales, do you have questions of the petition?
Just brief questions, Your Honor.
Go ahead.
Ms. Rutherford, have you had any communication with Mr. Rutherford since initiating for divorce?
No, I have not.
And have you attempted to reach out to him?
No, I have not.
And is that because you don't have any of his contact information?
Correct.
Okay. Your Honor, those are my only questions. I pass the witness.
All right, and already have your representations on the record regarding your efforts to contact him, which were extensive and acceptable. All right, anything else, Ms. Barron?
No, Your Honor.
Very well. I've reviewed the file and heard the evidence. I'm of the opinion that the divorce should be granted, and I will do so at this time. Having heard the evidence regarding custody, and property, I hereby grant judgment as prayed by the petitioner. I've reviewed the proposed decree, and I hereby approve it and render it as the judgment of the court. Ms. Barron, I will get with Elizabeth, and I will sign that, e-sign it later in the day or tomorrow, and get it to her, and then you can get with her to get a copy of it.
Thank you, Your Honor. And can I get a specific ruling on the family violence, please?
Yes, the court finds that family violence occurred in the past and is likely to occur in the future.
Thank you, Your Honor.
All right, anything further from either counsel?
No, Your Honor.
No, Your Honor.
All right, thank you all very much, and you're excused.
Thank you, Judge.
Thank you,
Thank
Mr.
you, Your Honor.
Rutherford.
Thank you.
All right. Elizabeth, have you been in contact with anybody in the chat, in the breakout rooms?
Miss Tristan just popped back in, Judge. She just needs to get into a breakout room with her client.
All right, which is whom?
Carruthers. Sierra
Yes, Miss-
Carruthers.
Sarah Crothers. All right.
And Elizabeth, do you have that order from Miss Barron, or do I need to save it as an exhibit?
I'm going to have her send it to me. I think it's easier that we can get it that way.
Okay, okay.
All right, Miss Tristan and Miss Crothers need to disappear here.
Judge, and also
Yes.
Ms. Cisneros would like to be put in a breakout room with Mr. Leininger. I believe he's popped back in.
All right. Let me do Miss. All right. Ms. Tristan and Ms. Crothers, you should have a request to join breakout room 4, and if you do, you'll be gone. Did you get anything, Ms. Tristan?
No, Your Honor.
Says you haven't joined breakout room 4. Ms. Crothers is in there.
I did not see a notification pop up like it did with Mr. Parrish.
Ms. Tristan, if you look at the bottom where it says breakout rooms, sometimes if you've already been in one, it's hiding down there.
Ah, thank you. Thanks.
Yeah, see, I don't know those things because nobody ever puts me in a breakout room. All right, and the next, Mr. Leininger and Ms. Cisneros. All right, Ms. Cisneros, are you on the screen here?
Yes, Your Honor, and I just got the notification.
Okay, and I'll put Mr. Leininger in there, see if he. Mr. Leininger, you should have received a notification to join breakout room number 3. See if you can find it on your screen and do that. Apparently he did. He's gone. All right. All right, of the cases that are remaining, who's ready to go here?
Your Honor, if Mr. Pluitt is not iPhone, who has come back on, I know earlier it was unmuted, but if that is not Mr. Pluitt, I am ready to proceed on a default on the Haley Pluitt protective order.
All right. Is Mr. Pluitt present here? Who is? I've got somebody in there.
Hello?
Who are you, sir?
I'm Mauro Lujano.
Okay. Ms. Flores, that's the person on the other side of the motion to enter. Do you need to confer with him?
No, Your Honor, we already have his signature, so.
They're just here to enter the temporary orders, Mr.
Your Honor, there's a problem with the order. And so it might be something that we should discuss.
When you say we, are you including me?
The state and Ms. Flores and the other respondent.
You want a breakout room?
Yes, Your Honor.
Do you have any objection, Ms. Flores?
No, Your Honor.
All right. Well, I don't see y'all up here. Oh, there you are.
I was in another breakout, Your Honor. Sometimes that moves you.
I'll find you. There you are. Okay, y'all should have received options to go. Ms. Latham, I've assigned you. All right. I feel like I'm in a circus juggling balls here. Ms. Riley, are you ready to proceed?
Yes, Your Honor, I am. If I could just ask Ms. Pluitt to turn on her video so she can testify.
Ms. Pluitt, would you unmute yourself and turn on your video? All right. Would you raise your right hand, please? Do you solemnly swear or affirm the testimony you may give will be the truth, the whole truth, and nothing but the truth, so help you God?
Honor.
All right. Be sure and speak up and go ahead, counsel.
Would you please state your name?
Haley Lynn Pluitt.
And are you the same Haley Lynn Pluitt who signed a declaration asking for a protective order on July 6th of this year?
Yes, ma'am.
And was that declaration attached to your application for the protective order?
Yes, ma'am.
Whom did you ask for a protective order against?
Mr. Kenneth Pluitt.
And what was your relationship to Mr. Pluitt?
It's my husband.
And are you a resident of Travis County?
Yes, ma'am.
Do you and Mr. Pluitt have 2 children aged 1 and 4?
Yes.
And do you have 2 other children from a different relationship?
Correct.
And currently, are y'all involved with a CPS proceeding on the 2 children that involves the 2 children you share?
Correct.
In your declaration, you listed incidents of violence that have occurred by Mr. Pluitt. Are those correct in your declaration?
Yes, ma'am.
And you put that the most recent act of violence occurred on or about June 21st of this year. Do you recall that date?
Yes.
And can you tell the court briefly what Mr. Pluitt did to you physically that day?
Yes, he showed up at my house. He punched, stomped, and kicked me repeatedly in the head.
Where did he kick you?
In the head.
And what other physical things did he do to you that day?
That was it.
Did he kick you once or several times?
Repeated several times.
And Your Honor, I would offer P1, which was admitted to the box yesterday.
All right, let me go to that. All right, I'm looking at a picture.
And Ms. Pluitt, did the police respond that day?
Yes, ma'am.
Did they take pictures of your injuries?
Yes, they did.
And
I'm going to put it on screen share.
thank you. And do you recognize these photos? Do you see photos on your screen marked P1?
Yes.
And do you recognize these documents?
Yes, ma'am.
Are these photos of you?
Yes.
Were they taken on the day that you just described?
Yes.
And did the police take these photos?
Yes.
And did they accurately show how you appeared when the police came out on that day in June?
Yes, ma'am.
And I offer P1.
All right, without objection.
Is Mr. Pluitt currently being investigated for the incident that you just described?
Yes.
At this time, does he have any charges pending for those?
No, not yet.
You also put that there was an incident in October of 2019. Do you recall an incident during that month?
Yes, ma'am.
And what did Mr. Pluitt do to you that day?
Punched me repeatedly.
And was this when y'all had gone to the Dollar General as you described in your declaration?
Yes, ma'am.
And were the police called on that day?
Yes.
And was Mr. Pluitt arrested for that incident?
No, he fled the scene.
I'm sorry?
No, he would fled the scene.
But eventually was he arrested and charged with assaulting you?
Yeah, he did a walkthrough. I believe he's going to court for it. I'm not sure.
And do you see what has been marked P2 on your screen?
Yes, I do.
And what are these?
Yes.
What are these documents?
Oh, pictures from what he did that day at the Dollar General, along with follow-ups of the injury because it took a while to heal.
And the first photographs, were those taken by law enforcement on the scene?
Yes.
And who took the follow-up photos?
Those follow-up photos were by the detective when I came in to talk to him.
And do those pictures accurately show how you appeared at the scene and then later when you went to speak with the detective?
Yes, ma'am.
And are those injuries that you sustained from Mr. Pluitt punching you repeatedly?
Yes.
And I offer P2.
Without objection, it's admitted.
And Ms. Pluitt, were you aware that Mr. Pluitt was actually took a plea back in February for this assault?
No.
But then after February is when the June incident happened, of course, correct?
Right.
Are you concerned that if you do not have a protective order, Mr. Pluitt will be violent with you in the future?
Yes.
Are you asking the court to enter a 2-year protective order protecting you and ordering him to stay at least 200 yards away from where you live and anywhere he knows you to be?
Yes, I am.
At this time, we do not have your children listed as they are involved with CPS, correct? And are you asking that in the future, we may be able to come back and ask that they be protected, but right now they are not?
Correct.
Do you know if Mr. Pluitt has ever had any family violence counseling?
No, he has not.
And are you asking that he be ordered not to communicate with you in any manner whatsoever except through attorneys?
Correct.
Does he know where you currently live?
Yes, but I'm moving at the end of the month because he found out where I live.
And are you asking that your future residence be kept confidential?
Yes, I am.
And to your knowledge, does he own or possess any firearms or ammunition?
No, not that I know of.
Your Honor, I pass the witness. I'm not seeking attorney's fees. I would leave court costs to the discretion of the court.
All right. Very well. I've reviewed the file. I've heard the evidence. I find that family violence has occurred and is likely to occur in the future. I'll order a protective order. I've reviewed, been forwarded a proposed order, which I have reviewed. I'll order that it be served on responded by email or in person, whatever would affect the service. It'll be for a term of 2 years, not to expire until August 20th, 2022. I'll further order that the respondent will pay the court fees due of $609 to the clerk, and that sum is to be paid within 30 days. All right. Is there anything further, counsel?
Your Honor, I don't believe so. Just as to the form, I don't know if the submitted copy or proposed order said that he appeared, so that may need to be corrected because I didn't anticipate he would be here. So
It said it doesn't have. We can check the one that said he didn't appear.
okay. I just couldn't remember if I left those options in or not.
No, you left blank there.
Okay.
But anyway, I've reviewed that form and I hereby approve it and render it as a judgment of the court. Again, I'll get with Elizabeth and get this e-signed as soon as possible and get it back to her. All right.
Your Honor, is Ms. Pluitt excused?
I'm sorry?
Is Ms. Pluitt excused?
You're both excused. Oh, you've got another case here, all right, do you?
Well, I usually hang out on our docket just in case something comes up.
Okay, well, if you want to hang out, that's great. Ms. Pluitt, thank you, and you are excused.
Thank you.
Thank you, Your Honor.
All right, we've had several people come back in from breakout rooms. Is there anybody? Are we ready on the Alvarado and Lujano case?
Judge, I think Ms. Tristan and Ms. Cisneros are ready on their 2 cases. They have some reset orders.
All right, this is on the Carruthers and Parrish.
Yes, sir. And Loveday.
All right, Ms. Tristan.
Yes, Your Honor. After speaking with both Ms. Carruthers and Mr. Parrish, it seems that we will need to reset this for a hearing. I have spoken to Mr. Parrish and the applicant, and we would like to reset this for September the 3rd. It's a 2-week reset for a hearing. And I will be sending an agreed reset to the court to extend the current temporary ex parte protective order, which would expire at midnight.
I don't see Mr. I don't see Mr. Parrish on the screen. Was he here earlier?
Yes, I wonder if he might still be in the breakout room, maybe?
I'll see. Yeah, he is. Let's see. I don't know what I can do. I can move him to another breakout room, but I can't. Unless I close all the rooms, I can't move him out of there. And I don't want to close all the rooms. Let me, how do you come out of that breakout room, Miss Tristan?
So at the bottom of the screen, there is a leave
Breakout,
option. Yes.
here we go. I'll go tell him that.
How you doing, man?
You're muted, Judge.
All right, Ms. Tristan, would you repeat what you said about the reset, Mr. Parrish?
Yes, Your Honor. So after speaking both to Mr. Parrish and Ms. Carruthers, we would like to reset this for a hearing for September the 3rd. And the state will be submitting an order to extend the current temporary ex parte protective order and setting this for a hearing for the September 3rd date.
All right, Mr. Parrish? You need to
Yes,
unmute.
sir.
All right, do you understand what the attorney just said?
Yes, sir.
Do you have any objection to that?
No, sir.
Are you represented by counsel?
No, sir.
You intend to be?
Yes, sir. Is that a lawyer?
Do you intend to get a lawyer?
Oh, no, sir.
You're just going to represent yourself?
Yes, sir.
All right, that's certainly a privilege. All right, is there anything further we need to do today, Ms. Tristan?
Can I have one more question, Judge? Do I need to get a lawyer for this?
That's up to you. These protective orders have serious repercussions, and you need to make a decision whether you need a lawyer.
Okay.
That's
Do
up
I
to
need? Okay, I'll just make a decision. But I'm not gonna break nothing. Don't plan on doing nothing.
Glad to hear it. All right. Ms. Tristan, anything else today?
The only thing that I just remembered that I will need Mr. Parrish's email address so that I can make sure to forward a copy of the extension. So I don't know if you would like.
I don't want to put you back into the breakout room. Mr. Parrish, can you recite your email address, or do you have one?
Yes, sir. kkmg78721@gmail.com.
Would you repeat that, please, Mr. Tristan?
kkmg78721@gmail.com.
Yes, ma'am.
Anything further?
Nothing further, Your Honor.
All right. If there's nothing further, you're both excused. Thank you.
And I guess, will the applicant also be excused? Is Ms. Carruthers also excused, Your Honor?
Yes.
Thank you.
All right. Ms. Flores, where are we?
Your Honor, Allie is here. Oh, yes.
Excuse me, Judge, Ms. Cisneros is ready to go on her reset, I believe, for the protective order docket to finish that out.
Oh, yes.
All right, I'm sorry, Ms. Cisneros.
Yes, Your Honor. I spoke with Mr. Leiniger and he was just served on Tuesday and needs more time to get a lawyer. So we are resetting to September 10th. He has given me his email address and I've spoken with Ms. Loveday as well. So she's aware of the new setting. I've emailed the reset to Ms. Lozano, so it should be over there shortly.
Ms. Leiniger, Mr. Leiniger, did you hear that?
Yes, sir.
Do you have any objections, sir? You
No,
have any
sir.
objection? All right. And
No, I do not.
Ms. Cisneros, you have all of the contact information for Mr. Leininger?
Yes, Your Honor.
Anything further?
No, Your Honor.
All right, very well. I'll grant the reset and you're both excused. Thank you for this.
Thank you.
All right, Ms. Flores, where are we with your case with Ms. Latham?
I've had a chance to discuss the order with Ms. Latham. I think she wants to address the court.
Yes, Your Honor. So the order there, it's legally appropriate. It's just an issue of putting it on our computer. But I discussed it with Ms. Flores, explained that we can't put the temporary order in our system, but there's a final hearing set for September. So we will just get it cleaned up for our computer at the final hearing. So I won't be signing off on the temporary order, but it's not legally inappropriate and I don't object to its entry at this time.
Do I have a copy of your order, Ms. Flores?
Yes, Your Honor. We emailed it to Ms. Lozano.
Yes, Judge, that would be the one that I sent this morning.
Oh, okay. It's not in box then?
No, sir, I don't believe it is.
All right. Oh, I got you. There it is. Is Mr. Lujano still with us?
I think
Is he in the breakout room?
he might still be in the breakout room.
I think he's gone. He's not on the, he's not on my list of people who are around. He's not in the breakout room. Do you see him, Elizabeth?
No, Judge, I don't. That's what I was looking for. I didn't see him in there.
All right. Ms. Flores, as an officer of the court, do you represent to me that that is in fact his signature?
Yes, Your Honor.
All right, very well. Hearing no objection from the Assistant Attorney General and having reviewed the proposed order and have the representation from counsel, I hereby approve the order and render it as the judgment of the court. Again, I'll get with Elizabeth and we'll get these signed electronically and get them to you as soon as possible.
Thank you, Your Honor.
Is
Thank
there
you, Your
anything
Honor.
else? Anything else from either attorney here?
Nothing
Honor,
else.
If I could be placed back on in the breakout room on the Acosta case,
Who are the other parties there?
Ms. Blott and Ms. Adelina Sanchez.
Okay.
Thank you, Your Honor.
I think I can do that. You should be on the way.
Thank you, Your Honor.
I don't know if you need to accept or not. All right. All right, Ms. Flores, if there's nothing else from you, you're excused. Thank you. All right. And we just have the one case left then, Elizabeth? You're muted. You're muted.
Yes,
Elizabeth.
that's it. That's all we have left. The couple, the party that's in the breakout room.
Okay.
Martina.
Well,
Tea time.
we have Mrs. Neros And Mr. Martinez here. Mr. Martinez is the petitioner.
Yes.
Ms. Martinez is on the Acosta case,
So they're in there.
and Mrs. Nero should be done.
Okay, I've still got her on the screen.
Yeah.
She likes us.
All right. Yeah.
I'll message her. May not be aware.
I can't think of any place I'd rather be. Why don't we do this? Let's take 10 minutes till 9:35. Give me a chance to get a drink and get this frog out of my throat. And then 9:35, if they haven't come back in, I'll go into the breakout room and find out what's going on.
Okay. Sounds good. I'm gonna
9:35.
go.
Just you and me. Except
I'm gonna call you. I'm gonna call you. We're recording.
Yeah, yeah.
Okay. I'm gonna mute myself though. Judge, are you able to sign those orders? I'm not rushing. I just want to make sure that you have everything. I'm just waiting on one more order from Ms. Tristan from the protective order.
Okay, I'm not sure if I can, I've never signed them out of box. So could you email me the orders separately?
Right. So the one that that divorce decree, I asked her to send it to me.
Oh, okay.
Which, you know, they should have all done. After they've been to us a couple of times, they know that I come hounding them for stuff. So I should be getting that from them for you to sign on that divorce. But then all the, so I'm only waiting on 2 orders, and that last one from the protective order and then that divorce prove up, and then I'll send those over to you.
Okay. All right. I guess I'll go see what they're doing in the breakout room.
Okay.
See if they're making progress or.
Mm-hmm.
Sure, I'm glad I put on a full face today, because I was thinking of just like doing a very little.
Front and center today.
Yeah, because I'm never online, and here I am just poking my head in and out. So
yeah,
it's all good.
I need to fluff on top.
Yeah, I just went and got a haircut the other day. She says, well, what do you want to do? And I said, well, I do want to keep some of the length. I'm still I'm debating about, you know, if I just want to just chop it all off or what. I said, but it's just gotten so heavy. I said, I just need a, like, man, it makes such a big difference.
Yeah, to get it layered.
Yeah, it just feels so much better.
Mm-hmm. I hear you, Mama.
Plus, it'd been since what, March since I'd been. So
y'all can't see, thank goodness, and which is why I haven't really like pressed forward to do it. But Oscar needs to help me put some tinta in my.
And the girls won't help. Well, I don't trust my girls, and Richard definitely won't do it. He's like, why do you want to do that? I'm like, because, although he's gonna be the first one to say, look, you got a gray hair right there.
Well, if it was a gray hair, it would be no problem. I'm like, you know, you've seen it.
Yeah. Well, no, I have them too. I mean, he makes it look like it's just one, but there's
mine. I'm like almost solid gray. I'm like 80%.
I think if mine were to be like that, like I would let it grow out just to get that gray. But I have like one here, one, they're just, you know.
Oscar, well, Luke wants me to do that, but now I'm at a point where I would have to cut my hair really short. I mean, I'd have a line coming down to here. How do I do? I'd have to go get it colored gray. And
yeah.
And I'm not ready. I'm not ready to do that yet.
Mm-mm.
Again, we're recording. We're sharing.
Yeah, we're sharing. Everybody needs to know all about us.
Mm-hmm. So,
you know.
Anyway, well, and tomorrow we just have 2 like 3-hour cases. Is that
right? 2, 3 hours. So I'm gonna firm them up today and just kind of check in to see what they're, you know, if they're still forward or whatever, just so that we can be better prepared.
And no adoptions.
No, we don't do adoptions.
Do we have them next week?
No, I think we just had them. Let me see.
Here comes Judge back. You're on mute, Judge.
You're on mute.
To me. All right. I talked to them. They've almost got it settled. I made a suggestion that I think settled it. She's got a lot has to talk to her client about it. I told them that if they didn't, I'm going to give them 15 minutes. So 5 minutes to 10. If they're not back in, I'm going to terminate all the breakout rooms and bring them back here and find out what the situation is.
Okay,
Go for it.
that sounds good.
So we got another 15 minutes to kill.
Okay, I'll work on exhibits.
And Miss Martinez, what is?
So she's on that first case, Judge.
Oh, she
So,
is.
yes, sir. So it's the attorneys that are in the breakout room.
She's the party, I see.
Yes, sir.
All right. Well, Mr. Acosta's in there. She does, but I don't guess I need her in there.
She's got
No.
Yes, no.
All right. Well, we'll just. Have you sent me orders? Elizabeth?
Yes, sir. I already sent you the other order. I'm going to contact the attorney to find out what's going on that decree so she can send it over to me.
Okay.
Okay.
Good enough.
I'm going to go on mute, but I can hear y'all if y'all need me.
Good enough. I'm going to mute me too. No telling what I'll say. All right. Ms. Blatt, Ms. Sanchez, where are
We were still talking about a possible agreement or proposal in regards to the visitation.
we? Ms. Blatt, you're muted.
Thank you, Your Honor. I apologize. So I think we have an agreement in principle with regard to the arrearage and current child support. Our only issue at this point is the method by which we begin possession and access between Mr. Acosta and April, April is 4 or 5 now.
4.
4. Is she in?
We're off the record, Shanna.
Is
Go
she
ahead.
in preschool, Miss Sanchez?
Yes.
So
It's not in a public school, but through a daycare.
Right. So we have agreed that April needs to
Let
be.
me make sure I understand. There was a agreed temporary orders that didn't address this.
No,
Today it's set for temporary orders.
Oh, I thought this was set for motion to enforce and for modification of temporary orders.
Well, modification of it.
Yeah, so what was in the original temporary orders?
no, sir. So there was an original decree or decree of divorce, and possession and access was provided for in that. And then we are here because Ms. Sanchez on behalf of her client, filed a petition to modify the suit affecting the parent-child relationship. We filed a counter petition, and today is a hearing on temporary orders as it relates to the petitions to modify the parent-child relationship.
All right, so on my docket, it says motion to enforce temporary orders. That's not correct?
No, Your Honor, it's a motion for enforcement of the latest child support order and possession and access as contained in the final decree of divorce.
And what has Mr. Acosta, has he seen the child?
Not at all, Your Honor. The last time he saw her was February 7th of 2019.
All right. Well, my policy would be, unless there's some evidence that he's an unfit parent or a danger to the child, assuming there's no such evidence, then it would be some type of graduated possession order
provision
with, step up, starting with no overnights for several months, then, maybe days for graduated to 2 days on a weekend, and then 1 overnight a weekend, and in that manner.
And
over a period of maybe 6 months.
So what we have proposed, Your Honor, just for background information, is prior to the time that he was detained by ICE, he was exercising visitation, never missed a visitation, and there were no issues. While he was detained by ICE in Pearsall, he tried to have communication with the child, but was denied communication. So what I am proposing, Mrs. Sanchez has proposed a step-up provision, as you suggested, first, third, and fifth. What we proposed is a step-up provision of sorts in order to get him back in a steady possession and access with April, is that he have the first 2 Saturdays following this hearing, 11 to 5, unsupervised at his home. And then the next 2 weekends, so it would be the 3rd and 4th weekend, he would have 11 to 5 on Saturday and 11 to 5 on Sunday. But in the interim, the child is going to be seeing a therapist. I've suggested capital area counseling. That's predicated on whether or not they accept Medicaid, and let the therapist, who's an objective third party who would truly have the child's best interest at heart, make the decision on when she's ready to go to a standard possession order. The other suggestion, which is totally out of left field, is that I could supervise visitation and make that it just.
We're not doing that.
Yeah, it's.
And Your Honor, just in response, I mean, we had initially proposed a 6-month stair step visitation. So for 4 periods on a Saturday, 1st, 3rd, and 5th of the month from 11 to 5. And then 4 periods of possession Saturday and Sunday from 11 to 5. Then 8 periods Saturday and Sunday from 11 to 7.
Yeah, I can't really follow that very well, Ms. Sanchez, without making. So here's my position on this, and I'll let y'all confer a little bit more if you want to. But my motivation is the best interest of the child, not the best interest of Mr. Acosta. I understand that he was in custody and unable to visit, and although he wanted to, but my thought is we gradually do it for the child, and not for Mr. Acosta's makeup time. And so, as your suggestion, Ms. Blott, about therapy, I mean, I guess the parties can do that if they agree to, but, or if either one of them wants to, but I think unless the child is having a lot of trouble right now, we can just do the stair step. And then if either party thinks the child is not adjusting well, they can come back to court and ask me to modify it again.
And by the same token, Your Honor, could we come back and say she's doing fine? We don't need to continue with the stair step and go to a full standard possession order?
Courthouse is open 8 to 5. You can certainly come back and say that. I doubt I would agree with it, but
Okay.
I probably won't be here, so some other judge may.
Okay. So, Your Honor, what would you suggest as a step-up possession order?
Ms. Sanchez, I'm going to make notes this time. So go over what you were suggesting.
Sure. We had suggested the 1st, 3rd, and 5th Saturday from 11 to 5 for 4 periods of possession.
4 weekends.
I'm sorry?
So 4 weekends.
Yes, for Saturdays.
All right.
And then
So 1st, 3rd, and 5th, and then 1st.
yes, 1st, 3rd, and 5th. As the second stage, 4 periods of possession Saturday and Sunday from 11 to 5 on the 1st, 3rd, and 5th of the month. And then 8 periods of possession set on the 1st, 3rd, and 5th Saturday and Sunday from 11 to 7, no overnights. Then
You're going from 11 to 7, from 11 to 5 to 11 to 7?
yes.
Okay. All right.
And then 10 periods of possession from 6 p.m. Saturday to 6 p.m. Sunday. So that would be the first overnight.
I'm not muted.
Okay.
And then they would graduate into a standard possession order.
After those, what is it, 16, 26 periods of possession?
Which is almost an entire year.
When's the child's birthday? 26 would be a half a year, right?
December 2nd is her birthday.
I'm sorry?
December 2nd is her birthday.
December 2nd. You know, that's similar to what I would do, except I would do overnights in that third period of possession.
And I guess that's something I can discuss with my client if she would be agreeable to that.
Do you want to go back in a breakout room?
Yes, Your Honor.
Yes, please.
Who are we putting in the breakout room? All three of you, or just Just Ms. Sanchez, just you and your client, or
Or just the attorneys?
not Ms. Martinez?
No, she's at our office.
Oh, she's with you?
Yeah, she's in our office.
Oh, okay. Well, do you need to talk to her? Do you want to mute and just talk to your client without going into a breakout room?
I can do that.
And
Okay.
I can do that too.
Okay. We lose Elizabeth, Shanna? There she is.
She's
I'm
up
right
there.
here.
She's
I
got
have a slide.
her backdrop.
Yeah. I'm filing the orders that you have, so I've got to email them about that last order so we can get that for you.
Good. We can do it tomorrow too.
Okay.
I've spoken with her.
Well, let's wait till Ms. Plott is back here.
Yes.
Yes, Ms. Sanchez.
Yes, so I conferred with her. She's agreeable on the third stage for 8 periods of possession to do one overnight from Saturday at 6 p.m. to Sunday at 6 p.m.
I don't understand.
So as the third stage of visitation, to do one overnight, and they would be from Saturday at 6 p.m., the first, third, and fifth, to Sunday at 6 p.m. for 8 periods of possession, or until we come back for a final hearing. Or
Yeah, and then the standard possession order would start after that?
yes.
For 8 sessions, you said?
Yes.
Correct.
And so after that, when we say a standard possession order, then he would get her on either Wednesday or Thursday. And then from Friday to Saturday, first, third, and third, correct?
Yes.
Between Friday to Sunday.
And what do we do about Thanksgiving that's in there? That's the only upcoming holiday that I'm aware of is Thanksgiving.
We can arrange some time with Mr. Acosta.
He could either have Thursday or Friday during the day, because that would be during the 11 to 5 period.
And so what would that take us up to? The end of the third stage would happen on what date? Does anyone know?
It's 16 weeks. For 16 periods of possession. Anyway, you can be in court on the merits long before this is up.
Yes.
Yeah. And would
Anyway,
we
y'all need to confirm more? Are you ready to do something to
just
the record?
a little bit more. So Ms. Sanchez, what about the therapist? Will y'all agree to therapy?
She's agreeable to therapy as long as it's covered by the insurance she has. Right now she pays like $500 on daycare alone. So, if he can cover the cost for the therapy, whatever Medicaid doesn't cover, if that's what he wants, if he wants therapy sessions.
Okay. So just give me a few minutes with my client.
And Your Honor, so as you know, the state only has interest in the child support and medical support issues. And my understanding is there's an agreement on those issues. And I was wondering if potentially we could put that on the record so that I could be excused. And if the parties need a hearing on the visitation issues, I wouldn't need to participate in that.
Yeah, you have any objection to that, Ms. Plott?
No, Your Honor.
Ms. Sanchez?
And just for clarification, I know that there were competing enforcement cases. And so as long as I guess it's my understanding that there's a finding of no contempt and no jail time for both of the parties. Is that correct in my understanding?
Yes, but we still want to discuss makeup time at some point for the periods that he missed from the time he got out of detention by ICE.
What? Wait a minute. That has nothing to do with the child support and medical support issues.
Correct. I was addressing her question about whether or not jail time would be, or the lack of jail time would be reciprocal. And I'm saying yes, but I'm also telling her we still want to address with her makeup time at some point.
And I think that would be separate from the contempt issue, Your Honor.
Yeah, completely. I'm just trying to accommodate the AG. If y'all don't want to, fine.
Right, we agree.
All right, well, let's go on the record then, Shayna. Ms. Latham, would you dictate into the record your understanding regarding support, both medical and child support?
Your Honor, I have the numbers for the arrearages. So the agreement will be that a child support judgment will be taken as of August 19th of 2020 in the amount of $8,000.17. And Mr. Acosta will be ordered to pay an additional $100 a month towards that judgment beginning September 1st, 2020. And then a separate medical support judgment will be taken as of August 19th, 2020, in the amount of $1,813.85. And Mr. Acosta will pay that back at $25 a month beginning September 1st, 2020. My understanding as far as medical insurance, Ms. Martinez will continue to be responsible for providing the insurance through the government medical program. And then I will let them tell you the current support numbers, but I basically told them they could agree to numbers as they wish, as long as the medical remained in place.
All right, Ms. Sanchez, what is the agreement? Is the support that was ordered in the divorce decree remaining unchanged?
Yes, Your Honor, and it was $247 towards child support and $67 towards medical reimbursement.
All right.
Well, my understanding is we agreed to $364 a month for the next 3 months in hopes that he will get a job, that Social Security will open again. And that, as Ms. Latham stated, 100 of that.
Ms. Blatt, I'm not here for a discussion. I'm trying to get an agreement on the record. Are you telling me you and your client don't agree with these support numbers?
I'm trying to follow Ms. Sanchez's numbers.
Your Honor, we had discussed doing a lower amount for 3 months to allow Mr. Acosta to get his Social Security card and hopefully
Had you discussed it or agreed to it?
Yes, we had agreed to the 364.
All right. I understand it then, both the medical and the child support that's in the divorce decree doesn't change. You have $25 a month on the arrearage, medical support arrearage, and $100 a month on the child support arrearage. But for the first 3 months, that is what, 367?
364, Your Honor.
364, and then after that, it goes to whatever that totals up to. Is that correct?
Yes, to what Ms. Latham had.
Okay.
All right. So 436 is the actual total. So how are you imagining the breakdown for the 364?
Okay, then we did not have an agreement because we agreed to 364 to include arrearage and current, however that worked out.
And so it was my understanding that it would be $267 for child support as the current amount, and then an additional $40. So that would be $307. And then
The child support's 247.
247, not
Sorry.
267.
247. Sorry about that. 247. And then an additional $40 towards the judgment, and that would be $287. Then $67 for the medical to continue, and $10 towards the arrears, so making it 77 total. And so that's how we got 364 for the following 3 months.
All right. So based on that, Your Honor, my understanding I'll amend my announcement. So it sounds like what the math would be is for September, October, and November, the payments on the child support arrears would be $40 instead of the 100 that I announced. And the payment on the medical arrears will be $10 instead of the 25 that I announced. And then beginning December 1st of 2020, the payments would be set at 100 for the child support arrears and 25 for the medical support arrears. Is that correct, Ms. Blott, Ms. Sanchez?
Yes, that's my understanding.
Ms. Blott?
Yes,
So that's the agreement of the parties?
yes.
All right, good. Thank you very much. I'm glad some other judge will get to try to interpret this exchange if we ever have to enter a decree. And Ms. Latham, thank you for your help, and you may be excused if you'd like.
Yes, Your Honor. And I'll let Ms. Blott and Ms. Sanchez know that that portion of the language I can draft relatively quickly and send that over to both of you. And then whoever ends up drafting, you can include that.
Thank you.
Okay,
Thank you.
All right, thank you.
thank you.
All right. Now, the only thing left is our visitation access. And do we have an agreement on the stair step we've discussed? Or do you need to talk to your client, Ms. Blott?
Let me talk to him for just 3 minutes, Your Honor.
Okay, go ahead and mute yourself, and I'll
Thank you.
waiting here impatiently.
Thank you. Oh, if we go before him, he's going to order.
You're not muted, Ms. Blott. I'll
Oh.
mute you. There you go. I did it.
Oh, we're missing Miss Sanchez. Okay, that's okay though.
I noticed you're unmuted, Ms. Blott. Are you ready?
We're ready, Your Honor. I was just going to speak with Miss Sanchez and say that, we prefer to go with the step-up provision suggested by the court today. And we would like to, for the minor child to receive therapy with capital area counseling, provided that they take Medicaid. If they don't, then Ms. Sanchez and I can get together and agree on a therapist for the minor child, and Mr. Acosta will be responsible for the expenses for that, to the extent that there are any over and above Medicaid.
Well, I've understood that the Ms. Sanchez and her client don't have any objection to the therapy as long as it's paid for by the
Right, and I'm
Medicaid and the respondent. I'm not going to put that in the order. That's going to be between the parties. Y'all can come up with an agreement on that separately. I'm interested in the access provision now. Do you have an agreement? We have an agreement on that.
Do we have an agreement, Ms. Sanchez, with?
I guess I had proposed doing that, the 4 periods, first, third, and fifth Saturday from 11 to 5, then 4 periods Saturday and Sunday from 11 to 5 on the first, third, and fifth, and then 8 periods with the one overnight, Saturday to 6 p.m. to Sunday at 6 p.m. Is your client agreeable to that schedule?
No, we prefer to go with the court step-up suggestion.
What was the difference?
The difference was that for the third period, that 8 periods would be overnights, one overnight Saturday and Sunday, and then a standard possession order thereafter.
Yes, and that's what I conveyed.
I think you already said you agreed with that.
Okay. Then yes, we agree.
All right. Can we go back on the record, please, Shana? Ms. Sanchez, would you dictate in the record your understanding of the parties' agreement regarding custody and access?
Yes. On the first, third, and fifth Saturday of the month, it will be day visits from 11 a.m. to 5 p.m. for,
Beginning the first Saturday of September?
yes.
Right.
And it would be for 4 periods of possession as the first stage. As the second stage, an additional 4 periods of possession. It would be the first, third, and fifth Saturday from 11 to 5, as well as the first, third, and fifth Sunday from 11 to 5. Then as the third stage, 8 periods of possession on the first, third, and fifth Saturday, beginning at 6 p.m., ending at 6 p.m. on Sunday for 1 overnight.
That's not what the.
And then from there, a standard possession order, or if we have another hearing, a final hearing. And we had also agreed to that Mr. Acosta would have, I guess, the Thanksgiving holiday time, either on Thursday or Friday from 11 to 5 p.m.
We'll let him choose, depending on his work schedule.
And what about her birthday?
That's December.
We can
December
schedule
2nd.
the 2 hours per a standard possession order from 6 to 8. Whoever's not in possession.
Is that your agreement, Ms. Blount, and that of your client?
Yes.
Just in case you ask them, I want 8 hours when they're ready.
8 hours on they split birthdays in Texas.
There's 4.
Then what?
There are 4, no 2.
Okay. So since we brought up the birthday, and I apologize, Your Honor, can we get a total of 4 hours on her birthday? To be
Whatever
decided by the parties.
birthday will be done by whatever the standard possession order provision is for her birthday.
Okay. So is that your agreement? Okay, yes, Your Honor.
All right, is that your agreement, Ms. Sanchez?
Yes, Your Honor, but we didn't get to discuss some injunctions. My client is just requesting the Children's Bill of Rights, as well as the no alcohol or drugs while in possession of the child or 8 hours prior to, no international travel to Mexico, and that the proper car seat be put in place for the child at the exchange, and that it be operated by someone with a driver's license. And I think with that provision, we did agree.
Yes, we don't have any objection to that whatsoever.
All right, very good.
And the only other thing that we had agreed upon, Your Honor, is that we would have drop off and pick up at the Austin Police Department. It's there on 8th Street.
Yep, well familiar with it. All right, is that agreeable as well, Ms. Sanchez?
Yes.
All right. I understand that to be the complete agreement of the parties. I heard previously the agreement regarding child support and medical support and the arrearages. I'll advise you that I find that agreement in the best interest of the child, and I hereby approve it and render it as the judgment of the court. Who's going to prepare the order? Is that you, Ms. Sanchez?
Yes.
All right, would you get with Ms. Latham and get the child support provisions, get the prepare the rest of the order and get it to Elizabeth at your earliest convenience. I'll get it electronically signed and returned as soon as it gets to me. All right, is there anything further we need to do today, council?
No, Your Honor.
Anything else, Ms. Sanchez?
Nothing further, Your Honor.
Very well. Thank you all for agreeing, and court will be in recess.
Thank you.
Thank you. All right, ladies.
Do you want to stop the recording, Judge?
Good thought. I'm not recording. I'm just live streaming it.